3, 2, 1. Is the voice good enough? Are we ready to go? Okay, we are ready. It was in the spring of 1962, and while sitting down to the breakfast table on the Today Show, national television, there was a fellow by the name of Norman F. Dacey. And Norman F. Dacey was being interviewed that morning because he had written a book. And the book was entitled, How to Avoid Probate. That intrigued me some because he had given, through the time of being interviewed, various reasons for creation of what is called a Massachusetts Form Inter Vivos Trust. And why should people be interested in those, according to him, was because that's what the rich and the powerful within the United States had been using. They had created them, they had used them, and continued to do so. And of course, once they expired themselves in the commerce within those trust organizations, there wasn't a probate of the estate. There was nothing more than the placing of dirt on top of the person who had expired. That all business affairs and all operations continued unheeded or undepleted, let's put it that way. And of course, there would not be court costs, there would not be probate fees or anything of that nature. As a farmer at that time, covering quite a number of acres of land, with the intent of purchasing additional acres if and when they become available, I could see that sometime in the future I would have an estate possibly that would need to be addressed to avoid that. And then he discussed the difference between having an estate plan that is a Massachusetts Form Trust from that of a will, and how that by transferring all right, title, and interest to property while you were living, you were able to avoid the death tax. There's only transfers that take place after, let's put it this way, they actually do take place at the moment, the second that you die. That is a taxable transfer as long as you still have your name on the assets. Now, many of you in here have heard about the constructive trust that's created for you in the District of Columbia the day in which you are born. Most of you are aware that that name that's created for you, that constructive trust, is entitled with all capital letters of your name. And that you are also held responsible as trustee, as a representative of that constructive trust to all actions of that constructive trust. Thus you have become, at the moment of birth, a citizen of the District of Columbia. Now, that was created for you. You didn't have any choice about it. You were too little to know what was going on. And so once you grew up and realized that something else needed to be done, that's at the point in time to take a look at what is really all available to you under the law. You have the right, any day that you live, to create your estate plan, whether it be a will or whether it be a trust. You have a right any day that you live to transfer assets that you have, tax exempt for estate planning purposes. And so you can do that. Now, I have seen over the years extreme cases of how that's been done and done very successfully. And to start out this afternoon, I wanted to cite you one of those cases because it's dear to me, because it was one of the biggest at the time and so far-reaching at the time for a whole group of farmers. I got a call from a judge in Cottle County, Texas, ordering my presence that week at Paducah, Texas, which is in the Panhandle. And there wasn't much in the line of details given because it was the judge himself that made the call. Now, I knew that this judge didn't have jurisdiction to order me to do anything. But he ordered me to be there that week. Well, you know, sometimes the deer will come right out in the middle of the road because of the lights, not recognizing the danger. But I racked my brain and I said, I couldn't have done anything wrong. And it's the first time in my life a judge ever called me and ordered me to do something. You know I'd have to go. And I got there. Now, I didn't get there exactly when I wanted to because I didn't have what it took. And, but a friend had just gotten a new diesel motor put in his car, and he said, let's go try it out, I'll go with you. So we got to the courthouse in Paducah, Texas at 6 p.m. on a Friday night. Now, have you tried that locally in your local county? And find everybody sitting on the courthouse steps, which were massive, including the judge, and the courthouse was still open. Now, I puffed up a little bit at a scenario like that. I mean, from North Dakota, other end of the country, and they're still waiting. We went into the courtroom. And the judge says, well, y'all, I've asked him to come here, and that's all I can say about this right now. I'm going into chambers, and he's here to talk to you about something. And so what did we talk about? What's on the fish today, the Massachusetts Farm Trust. You see, the judge didn't give me the rest of the story, but he knew that these people were facing serious economic trouble if they hadn't arranged their affairs. And there was this 5 families that each farmed their own farm, whose mother and dad, who had the major hub farm, had both just passed away. And they needed to create their mother and dad's estate. And because they were the perceived heirs, they were able to create that estate in a Massachusetts Farm Trust, even though mother and dad had just died. And so that was crisis number 1. Number 2, each one of the children, the perceived heirs, needed to create their own estate. And they was all there, and they was all still alive, but they needed to. And so that was the second order of business. Now, to facilitate that event so that it could be done timely and correctly, The judge kept the courthouse open all weekend for the filing of documents. Now, I had brought a typist along and some assistants of counsel, and the work was being done. It was Sunday night when it looked like pretty much was everything was accomplished within those 6 estates that needed to be done. And it was duly recorded so that now it existed and was on public record as a matter of law that we were kind of beat. And so we slept in a little bit, and this is Monday morning now. I get a call from the judge, and he says, "Y'all, hope you had a good night's sleep." Yeah, everybody did. "Come on over to this corner cafe over here," he said, "for breakfast." He said, "I'm buying breakfast." So we go over there, and he said, "Now that this is all done, maybe I can tell you the rest of the story." As county judge, he was going to be the judge sitting on the probate of the estate. And he knew full well that through the procedures of probate, that this estate would not be taken care of timely enough, because he knew something extrajudicial that was going to happen to destroy the original mom and dad's estate. And the whole story wouldn't be over until all of these families went to the banks and changed all of the accounts from one's personal name to one's new company name, the Massachusetts Foreign Trust. And that had to be done for mommy and daddy, and it had to be done by the 5 children in their own cases. And of course, when he got a call from these parties saying that they had gotten to the banks and made all of the necessary changes to the accounts and so forth, that we were called for breakfast. And when we got there and had the breakfast, and it's the first time I've ever had a judge buy me a meal. And I'll tell you, it was good. I can still taste it. It was bacon and eggs with Tabasco sauce. You hear me? He said, "Now, I don't want you all to leave town." Well, now being that I'm there, believe you me, if he didn't want us to leave town, we wouldn't be able to do it, because he could pick up the phone and take care of it so that we wouldn't get out of town. But he said, "I don't want you to stay here. I want you to go over to the Tasty Freeze and then give us much more detail than that." But you talk about perfect planning. Every 30 minutes, a new farmer shows up at the booth. Each one of those, for some reason or another, and there had been no promotional program of ours in any fashion, needed to have their estate planned. And we sat there for 14 hours. 28 more trusts needed to be done now. And so that was accommodated. Now, we don't hear anymore from the judge. Obviously, when you run out of so-called customers, it's time to go home. In other words, if you're from North Dakota and you're done, it's time to go home. So we do. And now for the rest of the story. This judge knew of a judgment that was coming out of Fort Worth, Texas, that would have destroyed every single one of those farms, because the liability under the judgment was in whole and in part against every one of them. And it was such a vast judgment, it was in some kind of an oil production scam in which they had made just a simple contribution to. but were being held liable for the total loss. And then, of course, without being able to defend themselves, the judgment was quite high and would destroy all of these farms. The judgment did eventually come in, and everyone was served notice of the liability pursuant to the judgment. Well, that was good, because not a one of them had 5 cents to their name. There was no farm in their name. There was no program in the ASCS office at that time that bared their name. They had no bank accounts in their name. They had no credit cards in their name. They didn't have anything in their name. So what's a judgment worth when everybody that it's against is penniless? That's what it's worth. If they hadn't put ink on the paper, you could have used the paper for toilet paper and flushed it. And so that was a lesson. Now, through all of this process, the judge created his own from what he saw on the public record. Are you hearing me? And it was a few years later, I get a call from him and asked to come on down and make a presentation again. And I do, at his request. And during a break, he comes up to me and he says, "Oh, Ron, and by the way, this judge's nephew was the famed singer Buddy Holly. And this is a fine, big Texas gentleman with the hat and the personality and everything that went with it." And he said, "You know," he said, "I got sued a couple of times in the last year." And he said, "You know, one of the cases," he said, "I won." He said, "Judges getting sued?" "Oh yeah," he said, "bankers, they don't hold any reverence to us." Anyway, he got sued. And he said, "I won the first one." So he said, "That was all right, you know." But he said, "You know, the second one I lost." "Yeah," he said, "I actually did." He said, "I still don't know exactly how I lost it, but I lost it." And he said, "Well, that was all right too." Because he said, "All of my assets were in trust." Now, he's still alive and well down there because I talked to him less than 3 weeks ago. One of the things about creating a trust is one's ability to pull himself out of the commerce, to actually zero out that constructive trust that's created for you because of the fact that you're no longer in the day-to-day business yourself. You're there operating the family estate, the company, if you please. And with that company, you can do everything that you could do in your individual name. Yeah, and there's many, many versions of that that can be exercised. The job here is to preserve the estate and keep it going during good times and during bad times. But also one of the things that it does is it protects the estate from the so-called last just costs. The horrendous medical fees, the burial fees, all of those things that could destroy an estate. In the early part of the fighting for closures, I saw that many of the farms had created extra debt because of the fact that the estates had not been properly planned and there was wills that were taken in and probated. And predominantly, but not everyone, but predominantly half of the estate would go to cover the costs of attorney's fees and the other probate court costs and so forth. And so they would borrow that money to pay these costs. And the farm could never generate enough revenue to pay it back. So it was the fact of prior poor estate planning that now had jeopardized the farm into foreclosure. So the job is to prevent that. Now back to Norman F. Dacey. Any one of you here can go to the B. Dalton bookstore or Barnes & Noble and get Norman Dacey's book, How to Avoid Probate. And it is still to today, which is now 40 years later, the Bible as far as Massachusetts Farm Trusts are concerned. Forms are in there, the law is in there, and so on. How you do things is in there. And so it's been time tested, at least for these 40 years. But anyway, I noticed that. And so, noticing something, trying to pay attention to it, recognizing it that it's probably a good plan is one thing. But it took me a number of years before I truly saw the need. Because my wife was ill at the time, and I knew of the tremendous expenses that were being run up. The insurance covered a portion of it, you know, that kind of a thing. But also the fact that we wanted to have continuity in the farming operation despite what would happen to her and or me, or both. And so it was in 1985 that I created my own Massachusetts Farm Inter Vivos Trust. Now, I can't stand here in front of you and practice law, so I'm not going to. I'm not deemed to be knowledgeable in the law, and you've recognized that. But what I can do is explain to you exactly how I filled out mine. And it can also go into the experiences that I've had preserving the estate while in that Massachusetts Farm Trust. I was also taught within the process that there is a statute of perpetuities for a trust. I was taught that after both my wife and I pass on, the life of the trust will exist for only 20 years and 9 months. So something must be done by that time. Well, there's a couple of things that can be done. One is the surviving co-trustees can sell off the assets if they wish and transfer them tax exempt to their own family estate plan, which each one of them now has, and each one has had one before they were even of age, because it facilitated going to school and every other method in which they've been using. Are you hearing me? That's a tax-exempt transfer for a estate plan person. Or if they want to leave the consortium together, all they got to do is register it as a foundation and it'll live forever. But that must be done before 20 years and 9 months after my demise, because I'm the last one. Also within the Massachusetts Farm Trust, there gets to be his and hers. You see, everyone has a life. So everyone's entitled to plan their own estate. And they can and operate that trust plan under the same name, the company name, whatever name you give it. And because each one has a life and they can plan their will any day that they want, they also planned their own will within the trust itself, just in case they failed to put something in that trust while they were living. It can be put in after death. So what do we have? We have two trusts operating off of the same company name. And our company is Western Life Trust. All right? Now, that operates all of the affairs. I am no longer in the Congress and haven't been since '85. I no longer generate income. I don't do any of that stuff that fits the Internal Revenue Code, as I see the Internal Revenue Code. And the court system has prosecuted me time after time after time. But you see, I have no money to pay for transcripts, for court-appointed lawyers, or any other thing. And a federal judge one day in court, recognizing the fiddleness of the system's prosecution, put on the record that as far as he knew, there was tens of millions of dollars of judgments against me. Now that's a bunch. And for a federal judge to recognize that, also he knew from firsthand that I had nothing of value. And so that he knew that if the government misunderstood my affidavit, it didn't matter, because he, the judge, knew I was penniless. Now, when it's finally been determined from the bench that they already know you ain't worth it, man, do you finally get to recognize what real liberty is? Nobody wants to screw with you because there's no way they can get a penny out of you. Are you hearing me? And that's really what most of the process in this country is to try to create an excuse to get into your pocket and pull the money out, or the assets that you're counting on to exist. Also, it gives you an excellent opportunity for the kids to recognize the estate, the value of it, and how it operates while you're still here. It puts away the conflicts that happen amongst families when mommy and daddy are no longer here. The trust needed a piece one day. I call it automobile piece because they're usually in trouble. They're usually a piece of junk in the long run. Whatever, we'll call them a piece. We went to this dealership, and my daughter, who wasn't of age at the time, was there along with my other two children, and they were charged with the responsibility of purchasing this piece for the estate as co-trustees. And so they kind of thought, you know, that they liked this one unit, but they didn't exactly like the price. And so, Dad, what do you think? And I said, why don't you let me give them an offer? And so I gave them an offer, and and they said, Dad, that's too little. Well, I want you to all know now, you know, this isn't the only dealer in town, and that's not the only piece that'll run. Give them the deal. And they said, absolutely not. They couldn't be involved in selling it that cheap. Oh, okay. Well, let's go, kids. We didn't quite get out the door. It's close. I got out, but they hadn't quite. And they decided to take it. So we went back to do the paperwork. And they get the feeling that my daughter is buying the car because she's the one counting out the bills. And then they discover that she's not of age either. But she's counting the bills. And finally the guy taking you know, he starts to make out a receipt and he just says, well, you're not of age. You can't buy a car. And she looks up and she keeps counting them. And she said, well, how old does a trust have to be? And there was a minute of absolute silence. He prepared the receipt and took the money. And she says, you do have possession of the title, don't you? Why, yeah, we do. He said, get it. Experience of doing and managing a business is so lacking in this country. More of it needs to be, and the earlier you start in life, the better you're going to be at it. Also, she discovered that she wanted to go through college, and we only had to fill out the first form correctly for her. Dad's income, 0. Dad's assets, 0. Oh, it makes those forms so easy to fill out. There was nothing but zeros and my signature, which equates to a 0. And of course, it seemed like every grant she applied for, she qualified for, because Dad was 0. Are you hearing me? Dad's such a 0 that the government right now doesn't want me to freeze to death. And so they contribute to that. The government wants me to see, so they contribute to that. The government wants me to be this heavy, and so they contribute to that. Now, if pride is a factor, do something about it. But your job is to do what you can to help your family while you're here, and not leave them with a bunch of controversy or problems when you're gone. And so that's kind of why. Usually when an estate is planned like this and is followed through with, you may go on out there in your own person and do risky things, but the liability doesn't fall upon the estate. It only falls upon you. And of course, once you learn how to run a trust, which usually takes about 2 years to get sort of good at it, once you have one, is that there are other unidentified business organizations that can be created to use to do risky things as well. And so it's a continued process of mental development within the commerce of this country, having yourself free of it. You see, I signed so many papers that other people wanted me to sign over my lifetime, and I never realized the consequences of all of those, and so I had to do something to contract around those to at least protect the future from what I had done. And that was one of the ways. And so the basic trust that I filled out is a Massachusetts Farm Trust that was modified by a group of attorneys in Phoenix, Arizona, for a Boise businessman, of which an attorney of his brought it to Fargo, North Dakota. And then, after looking at that, I further modified it to the point where it became irrevocable in nature. And thank goodness I had done that, because the last federal trial I had, the government lost in court because of the judge knowing better. And they appealed it to the 8th Circuit Court of Appeals, and I prevailed in the 8th Circuit Court of Appeals with that trust agreement. In short, the U.S. attorneys that brought the case thought it was a Williams standard and didn't realize it was a Brakke modified. It's your affairs. It's your estate. You print it up the way you want it. You hear me? Anyway, it's the only one I know of that's ever went through the circuit and prevailed. Anyway, so it isn't faulty, is what I'm telling you. But, you know, it took a little time and a little effort and a little thinking as to how to do it. And I wished I had learned something like this in school. I just could have saved everybody a whole hell of a lot of trouble. And a whole bunch of attorneys. And I filled courtrooms more than once full of just attorneys. Because there was that many moving against me. Oh yeah, I mean, all the king's horses and all the king's men are there, and you're sitting there without a sword. And so now we'll get on to the fundamentals here, and I'll show you what I did, all right? Now we got to get this piece out of my pocket here. Trust information. Before a person would think of doing their trust, it's just highly recommended that you go through a list of basics so you kind of know what's all involved. And right up here under trust information form, what are you going to name the trust? That's kind of, you know, number one, you know. What are you going to name the trust? You got to come up with a name. Well, there's some that use initials for names. There's some that use business names and so forth. I didn't know what to recommend other than it's more readily accepted if it's a business name within the whole process. But that's up to you. And an address. And the address could be a post office box, or it could be where you live. Are you hearing me? So if you all are jotting down, you know, come down with your name and come down with a projected address. Why? Because the trust is going to be doing everything from this point on, including filling out all the forms. Are you hearing me? Because you have a right in this country to create beings, not just sexually, but in the form of a trust you can. You can't form a corporation because those are creations of the state. They create them and they can cancel them. In this case, what you're creating, only you can cancel while you're living. You hear me? Okay, now, who's involved? Now there's a rule of thumb in trust. You must stop short of creating an ultra ego, the term they use. In other words, you can't be the Father, the Son, and the Holy Ghost. Now you can be two of the three, but you can't be the third, whichever one you wish to choose. You can't be the third. And so how do you do that? You do it by not a trusteeship, but a co-trusteeship, meaning committee. Committee decides. Now there's a time when I have been a co-trustee of Western Life, and there's a time when I've tendered my resignation for political prosecution purposes. And there's been a time when I've been reappointed again. Are you hearing me? So I'm a co-trustee. Now, so, you know, kind of my name's up front here, and of course my wife's name is right below me on mine, and because I'm assumed to be the manager, and that's usually the first one listed, but also it goes in succession of who should follow in the management role. Who would be the one in the family to best manage if mommy and daddy were gone? Well, I mean, they're next listed, and then the next, and then the next. That's not a means or a way of discriminating, because all are fair and equal. It's just who has the best, in your perception, management capabilities now. You can always change that. And you can change co-trustees, but I highly recommend that no one outside of your immediate family be a party there too. What's the reason for doing an estate in the first place? It's to carry on the bloodline and the benefits of all your labors and efforts, isn't it? Then who should be there? And everyone else should be omitted. Just recommendation. Alright? And so you get their names and addresses on there. And some of them might be miles away, you know. But name and addresses of now, if now is when you're creating it. Now, property, real property. Oh, I gotta slide this on in, he says. Can we all see it now? Real property is an important thing because not only does the grant deed need to be prepared, it also needs to be recorded in the county recorder's office so that the transfer of assets is made upon the record. And those transfers are usually made for $10 and other invaluable consideration. You hear me? And so the full description needs to be put on there. So what's the property and what's the description of it, okay? Then there's, I call it, am I far enough up, Randy? The rolling stock. Automobiles, trucks,
Keep it way up.
other farm machinery, things, you know, other things that are easily moved are usually put in there, and that's what's called the tangible property, the personal property. Usually made of steel and rubber and other things like that, house furniture and things like that. All right, we got trucks, boats, and so forth. What am I doing wrong?
Put it all the way to the top.
Run it all the way to the top. Oh. All right, so we got that one. And then we got number 5 here, which is intangible property. That usually goes on an assignment. And intangible property would be bank accounts, savings accounts, stocks, bonds, anything that has been reduced to paper. That's intangible property. That all got to be listed because not only is it assigned on an assignment, it is also, if it's in the case of life insurance, you have to change the beneficiary on the policy. And who becomes the new beneficiary? The trust. Yeah. And then we need the list of all of the children that are underage, because there's a guardianship paper. And of course, when we prepared ours, the 3 children were all underage, and so a guardian was appointed, and that guardian was my sister. And that's exactly how we did that. Okay, so that was the basic information that's needed. And then we can go down into the real fact of how we did it, as far as creation goes. Oh yeah, here it is. This is the taking you out of the intercourse in the Congress. Now, right up here, the name of the trust. There she comes, right under trust, the word trust registration. And what county and what state? Now, trusts can be registered anywhere within the United States. Anywhere. It can be registered in more than one county. And the reason for registration is generally to sue or be sued. That's usually the reason for registration. But the creation of it is not by recording it, but by producing the document. And so there we go. And who would prepare this? In our case, it was Western Life Trust that prepared it. All right? And then it's listed all the names and addresses of the co-trustees in descending order. Now, one of the things that happens in the destruction of farms is that a daughter or a son will go out and get tangled up with a member of the opposite sex and end up in a hissy fit and a fight ensuing and a possibility of liability on one side or the other. And of course, as long as you're still living, it's quite easy to remove one from the creation list. So not even the perception of an interest in an estate exists. But believe you me, the co-trustees are only perceived beneficiaries. They're not beneficiaries in fact. Because who's the beneficiary of this creation?
The trust.
Right, Western Life Trust. They're it. All right, so they all get listed here with names and address. And where are the records gonna be kept? There you go. And then down here we got the trust has not been registered elsewhere. Well, when you first created, that's a true statement. Anything that changes from there is by registering the same trust registration elsewhere. And there you'll have additional stamps on it to show that it's registered elsewhere. All right? But who established it? It's an inter vivos trust established by who? Probably the head of the family at the time it was created. And that's the person's name that goes in there. Okay? The registration date, down at the bottom down here, the rest is all standard copy. Registration date, that's usually an area where it receives one of the stamps from the clerk. But the signature is that of the co-trustee, the lead co-trustee. Signs and the name typed in underneath. All right, now, we'll pull this on down. On this, we'll go on here. That document with that signature that I just mentioned is signed by the creator, the trustor, the grantor. Those are all terms for the person that did the creation of it, before a notary public of what state, what county, and what date, and who appeared and signed? The creator. Only takes one member of the family to sign the creation document. And so that name is put right in there, and of course the notary does his or her thing there under. And those two documents, or those two pages, constitute the creation of a new being, a new person under the law. And you can go for the definitions even under the Internal Revenue Code of 7701 under definitions, and you'll see a trust has been created as of that instant. Why? Because notaries are all deemed to be magistrates under the law. And so you have a state witness to your creation, not your witness to a state's creation. And thus, nobody else can cancel it but the creator. Got it? Now, there's a document called trust agreement. Trust agreement is made a certain date, certain time. And this trust agreement is the deal. It's the deal made. That's why you got the agreement. Right under the name trust agreement put in the name of the trust. Okay, you got it dated between who? Now all of these forms, if you're going to create one yourself, need to be put on a computer so that you can make things all fit in form. You hear me? Because everybody's situation is different. All right here, this would be you, either a married person or you put in single person. If you're no longer married, you're a single person. And either a rural resident or a resident of, an urban resident. Are you hearing me? If you're rural or urban. In the county of and in the state of, hereafter referred to as trustor. And with, who's the next in line? Might be your wife. Her name would be first then, right there. And then yours in second place. And then the children thereafter. So they all go in there, unless you wish to disinherit one right off the bat. Because this determines inheritance or disinheritance, this form. Somewhere that's bad, Anyway, this is a document that never gets recorded anywhere because it is your deal, your instructions to not only yourself, to the wife, to the children, those that survive you. That's what this document is. And you're to follow that. It's the bylaws of the company, to put it in another form. All right? And so you got all of those listed there, and that's basically it to begin with. And the standard form, you can change anything in there you wish that would more facilitate what you want done. But there are several pages of this, actually about 6 pages to that document that don't require changes except for the last page of the printing material, which requires a disclosure under what laws? More yet?
Turn it around.
Oh, I got it upside down.
There.
Sorry about that. Right in here. Bylaws of the state of. That's got to go right in there. So where has it been created and what state? And then signed by the trustor with the name typed there under. Now, that is one trust agreement. And let's just call that his trust agreement. You hear me? Now what about her trust agreement? Well, we'll just go back one. And in her trust agreement, right up here, she, can you see it? She is the person that's either married or single, are you hearing me? Or a rural or urban resident, with the address in the state of, and if you are the husband, then your name comes first as the co-trustees, and then her name second, and then on to the children in descending management authority. All right? Likewise, then you get to know I get it right here, that it'll be in that state, and then it'll be her signature here as trustor typed in underneath as well. Now, this is done before witnesses. Okay? We'll get this down here. And this is kind of what this looks like. These witnesses are all co-trustees that witnessed the creation. and in the same order as they're listed in the heading of the trust agreement itself. Who's first? Who's second co-trustee? Who's third? Who's fourth? So the person that signed the end of the agreement is the second one that signs. Because the lady of the farm, of the family, is, in the case of the original trust agreement, is the first one that's declared, and so the lady would sign there. You hear me? And then the man signed there, and then the children based on descending order of management. And when that's done, that's not before notary, you understand, that's before those that's witnessing the production of this instrument. You have what is called acceptances, and the names are in the same order. Under the declaration of living trust created by the man, meaning this is the first one we're talking about now, on such and such a day of when, the same thing here. The lady's signature would go here, and signature there, and of course the co-trustees. That's acceptance of responsibility for management, and it's a chain acceptance. All right? Now, so far, we have the creation of the trust, and we have the equivalent of the bylaws, which is the trust agreement. Well, now it's time to I got it right there? Yeah, it's called the deed. The deed is made a certain day. Between who? It's between him and her, who are assumed now to have each half of the assets. Are you hearing me? Both of them are conveying it. It's their name and address, and they're conveying it to who? Western Life Trust, the name of the trust. That's who they're conveying it to, whose address is whatever address you've given the trust. Because the trust becomes party second. And it's right in here. You got the county of and the state of. The reason, if you've got property in one county, you only got to do one grant deed. But if you've got property in 2 counties, or 3 counties, or 4 counties, it'll take that many deeds for whatever parcel or parcels that's located in that county. So you have to do more than one grant deed, because they got to be recorded in separate places. Are you following me? But the full legal description goes in here, so that's parted on the machine, and you put in the full legal description of the assets. And then, once that's done, right down here, Western Life Trust will pay the taxes from here on. And there you've got the grantor signing, both him and her. So that would require another line. Move it back up. That would require a second line for you to put in. And, my goodness gracious, we'll move on to the notary part of it, because that's got to be signed before a notary. Here we go. In the state of, county of, and then in this case, of course, besides the dates, you've got both appeared, so both names appeared before the notary. The notary does her part. And in most states, this is required. I certify that the requirement for a report of or statement of full consideration paid does not apply, because this deed is for transferring title of property via the sale, wherein the grantor and the grantee are of the same family or corporate affiliate. Follow me? And of course, the grantee would be the seal of the trust is what you put in there. So if you wrote the trust name in your free hand, that is the trust's signature. Follow me? And then by who for the grantee would be both him and her. So we'd have two lines there as two co-trustees. And then this, who prepared the instrument? Told you at the beginning, Western Life Trust, or the name of your trust prepared it. Name and address would go in there. Follow me now? Okay? That's how you do the deed. So transferring it before a notary is not complete until it's recorded at the recorder's office. Usually, that's the case. Bill of sale. We've got the date, needs to go in there, and it's between. Who's doing the selling? One of you or both of you are selling the personal property, the tangible personal property, to. And who is getting it? Western Life Trust. They are the buyer. They don't have to sign for it because it's a bill of sale. It's those who are conveying it have to sign for it. Selling. And you can see all of the things that can be involved in that transfer. Now this is a generic form, and usually it covers all of those things, but if you want to be explicit, you part it right here and then move that down and put in case of automobiles, make, model, VIN number. In the case of tractors, combines, swathers, all of the list of equipment, however long it takes, however many pages it takes to list it. All right, and then the seller or sellers of it. And guess what? The bill of sale is conducted, like I have explained before notary. And then who prepares the instrument? Again, the trust itself prepares the instrument.
The trust itself prepares the instrument?
Yep. Their trust name and address is always the preparer on everything. Okay. Now, we get to the intangible property. This goes on the assignment. And some trusts that I have seen have several different assignments. They're created the same way as the bill of sale, with date and who's transferring to who. But also, in the case of the general consideration of $10 and so on and so forth, you list bank accounts by name, bank, and number of the account. And a lot of the assignments are done for each specific thing. Like if you've got government stocks and so forth that you want to transfer the beneficiary of, just put those on one. If you've got bank accounts, on one. If you've got insurance, a life insurance where you're going to change the beneficiary, do just one. Because you don't want anybody else to see other stuff. Because most of the time they're going to want to take a copy of this in order to affect the change of the beneficiary. And you don't want them to see all kinds of other stuff that's none of their business. And so, that's basically a one-page document anyway, but try to keep the intangible stuff separate for a particular use. You don't want the banker to see all of this, that, and the other if you're only going to change your bank account. Getting the picture? So you can create as many of those as you need to separate things. Bear in mind, though, you must make the request, like in life insurance, to change the beneficiary. And of course, usually the documents required are the trust registration document and the assignment. And then your instruction, change the beneficiary to the trust name, all right? And so then you got the assignor down here,
Take that out.
which is the individual. Oh, I gotta slide this up a little bit. Okay, which is the individual. If it's a life insurance on the man, let's take that. He's going to sign right there. And he might just as well sign over here too, but here, the assignee, is he signs the trust's name by him as co-trustee. He's the only one that can assign his insurance. He's the only one that can assign his bonds if his name's on it. Following me? Or her. Now, if it's an account where there's two names on it, then both. But only one person needs to sign the trust name, but both need to sign granting it. Okay? And so those are typed in there. You just move in, put another line for the second co-trustee. And then before the notary, the same. One or both names go in here, and then the notary endorses it and puts in her expiration date and so on and so forth. And once again, prepared by the trust. You got that all now? Okay. When we get done here, I'll open this up for questions if you got any. So don't worry about that. Now, one of the things that seldom happens in this country, at least it's not very often, is the declaration of homestead. Most people haven't declared their homestead exemption pursuant to law, and it's federal law. And you can elect to use federal law or state law if it's better. You get to pick the best. In North Dakota, it fits sometimes to use theirs, which is $80,000 net contiguous. So if you've got a section of land where the sum equity in it is less than $80,000, you can homestead the whole 640 acres and make it exempt from process. But this is a way of the head of the household, whoever that may be, man or woman, can actually fill out and create that homestead exemption. Whether you're city or country, makes no difference as far as the homestead declaration is concerned. And merely answer the simple questions here. State of. You follow me? I, whoever's doing this, and then I again. And what you've done here is effectively transferred your homestead right to your estate. And of course then in many states they have less taxes on a homestead than a non-homestead. And so this allows you to get in on the tax reduction as well. Following me on through here? And of course, you declare the legal description then of the homestead, right in that area there. Take this back up some more, right in this area right here. All situated in what county, what state. All right? And also you declare your trusteeship here of the trust, right in this position. So you list Western Life there. And for $10 and other good and valuable consideration, this blank day of, and of course this is done before a notary again, and who prepared the document. If it don't all fit in one page, so it's 2 pages. Following me? But most have not declared the homestead exemption and should. Alrighty. For the young children, appointment of guardian. We follow through here. It's either we, if there's a husband and wife, and this is created, both of you in here, hereby nominate, and who, and where, okay, a guardian, a person and the state of their children. And what's the estate? That would be also a guardian of the trust affairs until at such time as the child can take over the management duties of that estate. Now, if you got any question on any of those, I'll try to get it to you here, right here now, but the bottom line is it's the same follow through as in the other document, and you got the parent or parents signing here authorizing that appointment, because that person that comes in to help keep the little ones together and keep things in shape need to be able to execute the bank accounts and things of that nature for the care of the little ones, and they've got to have the authority given from you to them in that case. And of course that document isn't recorded anywhere, it is kept within the trust documents. Okay, and of course back in front of a notary again, which is a magistrate. Now, the reason you can do all this and do it on a tax-exempt basis is because of the most valuable thing coming next. You got it there? Last will and testament. A lot of people don't have wills at all. This will serves two purposes. One, it qualifies what you're doing as an estate plan, and it also qualifies it as any assets transferred into it are transferred into it tax exempt on the transfer. You hear me? And this will here is the testator will. That's the man. He's the testator. And he's a resident, whether it be urban or just or rural, and wherever he is, it's put in there. And that he has so many children. You put in the written number plus the number. That I have given all my estate and property to the co-trustees serving at the date of my death in such capacity under the terms of the certain living trust dated. All that goes in there is the date of the trust as it's been created. Okay? And of course this can be done before 3 witnesses. You'll sign then as testator, if you're the man, in front of 3 witnesses. Now, so you got the witnesses' names and addresses there. All right. Well, there's one more page to this will, and I'll tell you why the will in its entirety. Here's page 2. This is in front of a notary, and here the witnesses sign, and the witnesses sign. Follow me? Each one of them, in succession. And right under this, there's a place here we put, and the testator's name goes in here, whoever's creating this will. Alright? And here the testator signs with his name typed in underneath, and he's subscribed and acknowledged before me, and that is the notary situation at that point in time. That's the conclusion of it. And these are usually typed in, but they can be written in as well. Alright? Now you got the will. Why would you want this will? Told told you, to exempt you from the tax transfer. It's number one. Number two, what if some enterprising attorney finds some co-op stock or other interests that you failed to transfer while you were living, and he elects to file for probate? Now, I'm telling you, you don't get probate without filing the original will. And if there's some asset out there that he's found, he would try to open up the whole estate to probate if he could get away with it. This will prevent that, because the survivors of your demise can take that will and file it with the probate court for the purpose of probating that one item that was found, if there gets to be a controversy on it. It's a way of protecting the estate from not getting opened up. And it's tailored very carefully for that purpose. Sometimes that's the easier way of handling it. Because what's co-op telephone company stock worth if it didn't get transferred while you were living? You hear me? A power company might be more than that. I know ours is up over $6,000 at the present time, which they'd like very much to steal if they could. But anyway, this is the lady's will. It's filled out the same as the man's, except for the lady's name is on there, and she signs as the testate rex. That's the name for the ladies. All right. And of course, so they're basically identical, except for the interposing of the name of that represents the female gender. And that's done before a notary, exactly the same as the other one that we went through. Follow me? Okay. Now that this is all done, you can elect to register the trust registration or not. That's your option. But the property won't have transferred without being placed on the public record for others to know, because they're entitled to notice. All right, now, do we have any questions? Yes.
Can a person just singly have a trust?
Yes.
Himself?
Yes.
And
Sure can. Yeah. Several of them have been done to protect the estate from other things. Yes.
How about one of your trustees happens to be a baby right at the moment?
A what?
A baby, 2 months old.
2 months old?
How do you handle that?
Put a pen in his or her hand.
Circle.
They're fully capable of conducting business within the frame of the trust. And that's a witness of it. You know, there are people who do farm in this country that are illiterate to the point that they can't write their name, and so they use an X. Yeah. And a witness to it. Well, there's nothing bad about that. But we've got a judge in Fargo, North Dakota that can only use a half an X. And he raises millions of dollars a year from the taxpayers so that the city can spend it. And he uses that's it, a half an X, with no witness. Of course, there's one reason for that. He also never took an oath of office either. Any other questions? Yes?
Well, I'm alone. I'm gonna leave it to the neighbor kid and his wife. Now, if they would happen to divorce and split up, how would happen in that kind of situation?
As long as you're alive, you can modify that agreement.
Yeah, if I didn't have to
Yeah.
worry about it.
Are you hear me? You just produce another document, which would be the last one filed, which would make the change that you see necessary at that point in time. Now, there's another thing you can do with the trust, and that's pretty important, and please pay attention to this. If you want to make a change in the trust, don't feel you have the time or the ability to make that change, write a letter to the trust giving your specific instruction. That letter is the same as the modification in fact. So there's nothing wrong with writing a letter to the trust making a change. You may not be able to get out of a hospital bed or whatever to get stuff recorded. Do it. What it is you want done in that fashion. And of course, if you walk out of there someday, you can always make the physical change on the public record. Are you hearing me? That's subject to change as long as you're alive. The instant you die, nothing can be changed on it. However, the surviving co-trustees can decide to continue with the operation of the business or to divide the business up to their pro rata selves and do so. And I prefer, that they at least know that they can transfer it to their estate, their own estate, tax exempt. But if it's transferred to them, they're going to have to declare a certain level of income pursuant to the tax code. One of the reasons that I saw, and now this is an extraordinary case, but I've seen quite a few of these extraordinary cases. A person who is deemed to be a laboring man, who, due to financial difficulties, ends up in separation and forced to pay child support and all of that stuff, which is all important stuff. But what do you do when you can't do it? Well, it was a number of years ago, a fellow came driving over to the office where I was and said, I'm due in court tomorrow to show cause as to why I should not be found in contempt for failing to pay child support. I said, tomorrow? Yeah. I said, you got any money to pay it? No, I don't have nothing. He said, I've barely got enough gas in my car to get home from here. And I looked at his car and I was wondering if that would make it to where it was he was going. In other words, Brooke applied to that man at that time, no question about it. Now you want to hear somebody who figured he wasted his time when I said, the first thing you got to do, son, is plan your estate? I could just picture that look of utter, total waste of time. The last gas that he had was spent coming to talk to somebody that somebody had told him might be able to give him some helpful suggestions. Yeah, because that was his problem in the first place. You see, in order to be able to contribute to his children, he needed to be able to increase the ability to raise the revenue he could keep. And one of the things he wasn't doing was keeping any receipts to cover what income he was getting. Now, however little it is you're getting, if you're agreed, and he agreed to pay child support, and then of course they kept raising it and raising it and raising it, and the basis of the first agreement, so he couldn't pay. He didn't have any proof to show cause, because he didn't know what the law was, and the law was what? He had an absolute right for the revenues that he did get and did make to take care of himself first. That meant automobile, that meant apartment rent, that meant heat, lights, clothes, including entertainment. That's all a matter of law. And what did he, that included a beer, if that's what he wanted. And what did he have for receipts? Nothing. So his show cause would have been in receipts. And I said, man, if you don't plan your estate where you operate in a representative capacity, I said, you ain't never going to keep your affairs in order, because it has to be a trust billful. And these are trust funds. And whenever they leave the billfold, what do you think goes back in place? That's right. Not only that, if you learn how to hire out your trust, and there's a little method to accomplishing that, you won't have any state or federal withholding, which will increase your take-home by about 35%. Now, to my knowledge, as of this day, lots of individuals have picked themselves up from their bootstraps, purely recognizing the need to operate in a trust capacity, with the record keeping being able to support the problem of being able to show cause. And company after company has learned to hire these people that have managing their affairs on that basis, because it costs them 10% across the board less to have them than those who haven't planned their affairs, because they're hiring a company, which is merely a 1099 transaction and not an individual. What's happened in every one of those cases where the people started managing their affairs properly? You're not going to believe this, but every one that I know of to this date got ahead enough, and the trust started making contributions directly to the children. It's called payments, not compelled payments. These were the voluntary payments made as a co-trustee to the other co-trustees, which were the children. You hear me? And when you don't pass it through the state, if you're a man, they'll take 9% of what you pay in out of the check. If you're a lady, it's 2 or 3%, depending on what state you're in, out of the check that's given. And so then the children got it all. And then, of course, managing the affairs grossly increased the income. They become more valuable showing up than anybody else. And the net gross take-home goes up. And I got a kick out of this one truck driver, and the company even bought him a brand new truck because they wanted his trust to stay. Those people do quite well when they start managing their affairs. And that's so darn important. That's so important. Anything else here? Yes?
What's your question, like, let's say he owns the trust, let's say if I get real sick and have to go to nursing home, is there any way the nursing home will get all that?
No. Now, in some states, they like to be able to impose their will on state-created trusts, whereby they can access those assets unless they've been in trust for so many years, like 2 years, or in some cases 3 years. But these aren't state-created trusts.
So they can take the money out?
Lawfully, they cannot.
Okay.
Lawfully, they cannot. I guess willing parties can give away anything, but lawfully they cannot. And so that protected us in our estate from my wife's last so-called just costs. And I got sued afterwards on what was called a perpetual overcharge during all of the treatment period. And I ended up getting sued in court and losing. And what good did it do them?
But is there any way protecting that they can't?
It's one way of protecting. You know, when you're dealing in farms, businesses, and homes, you don't want that to go up on the auction block because of medical costs. Those people were given a privilege to practice medicine in whatever form. And with that privilege came it the burden of providing the services regardless of the ability to pay. But I've seen medical services destroy estates and farms.
Like my mother's, the whole thing.
Yes. Yeah. Yeah, and so this is a state protection. And the sooner one does it, the better, of course. And there isn't any great cost in it. Most people that are very destitute can do it. I mean, the forms, you know, they're available there. They're available off the tape here. You can see what they are. You can type them in if you want. That's why they're being put out. If it'll help and it'll work for you, there it is. If you went to a lawyer and could find a lawyer to do anything other than a testamentary trust, he would charge anywhere from $2,700 to $3,300 for just typing your name in the particular spots on the computer. Well, you know, not everybody can afford that if they could get it done. But they want testamentary trusts so that the property doesn't transfer until the instant you die. Because they're in the business of handling estates. And they can't even get away with it then if they don't get the original will. You got a will done up, one, be sure there's not two originals with the attorney that drew it up having the other original. Are you hearing me? You get the originals out of circulation, get them here, and then be sure you leave instructions that nobody file the original will with the probate court. Then the court will not have jurisdiction. You tell the survivors, you manage it pursuant to the terms and conditions I've laid out.
Like my mother farm money ran out for the nursing home. A week later she died because she didn't have a line of duty. And the probably just happened.
Yeah. Well, that's avoiding that scenario, is what I'm telling you. That's why you plan it and make the transfer up front, because it's also tax exempt. But the same way with these wills, they don't really become taxable until they're recorded. That's the real part of it. It's not taxable until it's recorded in the probate court, and then the jurisdiction is there. It's there by contract. You can administer that will. Now I have a friend out there in Graceland that she handled 2 estates. She handled the one of her husband, but they had a trust. And she managed to take care of everything with that trust. Her mother didn't have a trust, and her mother-in-law didn't have a trust. And so she had to take care of those. And the first thing she did was get those wills out of circulation, so she had them, and she's the perceived heir, and she administered them. Plain and simple.
How many years do you have to be in the trust before, did you say 2 years?
I just say in some states, if it's a state creation trust. In Minnesota, for instance, they have a 318 trust, which is a state trust, nothing more than a testamentary trust, where the state can cancel it even. That's the ones they have jurisdiction over. None of these states have jurisdiction over your estate plan. Right, right. That's right.
How do you get a will out of circulation?
Go get it.
Pardon?
Go get it.
What if you can't get it?
Well, you have a right to see it, don't you?
I suppose you do. Now I got one more question. If you got a trust and you got your vehicles in that trust too, and you get in an accident, can they come back on you?
The answer is yes.
Well, if you got everything in that,
Yes. So if you have vehicles in the trust, be sure you have adequate liability on them. But usually people got to create a trust to learn how to operate one. Would I ever put vehicles in the family estate trust now? Absolutely not.
you have a separate.
And are they right now? They absolutely aren't. They're in this U-boat, and they're in that U-boat, and they're in that U-boat, and they are not going to drag down the family estate. So the worst that can happen is the piece of junk and whatever's left of it, they can get by taking it, physically taking it away, but that's all they're going to get. It's a very good question. Now, you don't want to do things in your family estate, once you got it set up in an operation, that are risky. You can do those risky things in your own name, or you can do those risky names in an unidentified business organization. But, I have continual liberty by taking myself out of the commerce and then only participating in the benefits of programs. That's how I've had to exist. And that gives me the ability to do what Ralph Nader has perfected. Because IRS has the ability to come out and show somebody a paper that they must have made somewhere between $20,000 and $30,000 last year, because in their determination, you would have to have that much to exist. Well, if they live in Chicago or New York or Kansas City, that's probably how much money they'd have to exist. But out here in rural America, you can get by it somewhat less. Nevertheless, I have to be able to answer that old hard question if it ever comes. Well, how did you exist? Well, Ralph fixed it up. He created a service credit program, otherwise known as Time Dollar. And he set up clearinghouses in some of the major cities to keep track for the 44% of the people in this country that can't even have a bank account. That's how many can't have a bank account. But they can use his if they want to. Anyway, how does it fit with the trust? I have an agreement with the Western Life Trust where I provide services in exchange for credit. Now, Ralph got 2 opinions from the IRS, one out east and one out here in Central America. One was out of Kansas City and one was out of Washington, D.C., where they determined that service credits were not a part of the tax code. And therefore, because they weren't part of the tax code, they weren't taxable. Because if they would have been made sometime in the future taxable, then the government would have to be able to accept the service credit as payment of taxes. And he got those dim bulbs to sign off in 2 parts of the country to the fact that it was not a part of the tax code, therefore it was exempt. They also got him to determine it was not barter. because barter is taxable. You hear me? So what happens? I provide services every day, 12 hours a day, 7 days a week. That makes it very clear. And in exchange, I get credit. Well, what's my credit? The mere necessities of life is my credit. And so you saw trust funds. I carry their money. I spend it for the mere necessities of life. And in that fashion, it is totally 100% deductible for the trust. They provide heat, lights, whatever portion they pay. They provide rent, repairs, gasoline, and you can see I eat. And when you think about it and think deeply on this, whatever more do you ever get out of life than the necessities of life? There's people that get puffed up if they own something in their name. But you can see I'm puffed up. And I don't own anything, including the shirt on my back, because I never bought it. Whatever is purchased, the trust purchases for me. And whatever is generated, it's theirs. And I like that a lot better. And it works well in private banking too. It works very well. Nothing. So now you can see why I'm free of confinement to be here today to visit with you. Remember now, all I've conveyed to you is what I have done personally. My wife did personally while she was alive. And merely conveying it to you, so maybe you might find something in there that you might want to use that'll benefit you. And with that, is there any more questions before we call this to a close? Yes.
What parts of this trust do you actually have to record at the recorder's office?
If you want to transfer ownership of the property, whether it be grant deed of the real estate, record the personal property, tractors, combines, cars, whatever. And the other thing that you'd record at the courthouse would be the assignments. Those are ones that you can record at the courthouse when and if you feel it is important to do so. They don't have to be recorded instantly. Same way with the trust registration. You can have that all prepared and operate under it. You can even, if you wish, request an EIN number for the trust from the IRS using an SS4 form. But be sure you keep your Social Security number off it. Yes.
Do you have to have that in order to operate the trust?
No, you don't have to have that to operate the trust, but that's up to individuals and their management decisions. See, sometimes you can make other things work more easy for you now doing it this way than if you went that way. And that gives you the option. You have a lot more options here to operate and manage the affairs and work around what you can perceive as problems. And that's one of the reasons why you want to do it. You want to be like Attorney Bill Williams would say, flexible.
What if a bank asks for your account number on the trust, what are you going to give them if you don't have one?
Well, you can give them that you've applied for one.
If you're a naturalized Indian, can you use that membership number?
Well, I haven't connected those with trusts yet, in my case, so how can I speak to you from being an expert on it? I can't. But the little shell is another way of doing things more simple than a conventional way, and with it taking less time in many fields. Not in every case, but And people get pretty astute after a while at figuring out, you know, what is bullshit and what isn't, and what they can do with this that they, you know, that they can't do with that. And it's that innovation that keeps the government at bay. Because they're dealing with all kinds of bureaucrats that aren't as hip as we'd like. And one of the things that, you know, that you should possibly consider is that when somebody's telling you something, if they're giving the government a lot of credit for knowing what it is they're doing, it may be a scam. Because I find them least knowledgeable as a whole of knowing what it is they're doing. And I would just like them to follow the law, but they don't know what it is. And they don't have a system of teaching them what it is. And that's part of the problem we got in the economy here right now. Like I said in another meeting, my goodness gracious, Mr. Greenspan, rather than saying nothing to Congress every time you meet with him, why don't you start teaching your employees in the Federal Reserve the law so they will follow it? Right there is the hub of our economics right now. The lack of knowledge at the very top. The old timers have moved out of that system, that new. Nobody's teaching it. And I've talked to some of the Fed's former lawyers. I mean, they're not pulling this out of the air. He just says it's a fright. And you can even go to, you know, the headquarters of organized crime in Fargo, and you can find cops there. And one of them's a Native American, and he just says, these new cops, oh, they're just bad news. They're out there playing King Kong without the tools. Yeah, and that's what we all got to watch out for, is these hired persons that's supposed to be there to protect and serve. And they don't know how. And so they're dangerous. They're running around with guns and badges and spending your money doing it. Thank you much for your time. I'll be around for any other questions you might have. All right, have a nice day. God bless you.